employees that are on salary, front desk managers. All right. Right now, salaried employees who do managerial, professional, or sales work can be classified as exempt under the Federal Fair Labor Standards Act and the Minnesota Fair Labor Standards Act, and they're not eligible for overtime. The standard under the Federal Fair Labor Standard Act is established and the state follows it. Right now, they have to make approximately a little over $20,000 a year in salary and provide, quote, a significant amount of their time in managerial work. About a year ago, President Obama issued an executive order directing the Secretary of Labor to review and reevaluate the exempt standards. And about 3 months ago, the Department of Labor issued draft standards that would raise the threshold to qualify as exempt to $50,900, so by more than double. It is the 40th percentile of the wages earned by all exempt employees in all industries in the United States. So we get lumped in with Google and Twitter and Facebook and the Mayo Clinic and Wells Fargo, and it's just stupid. We did submit comments on behalf of all 3 of the coalition trade associations, along with the ARVC and the American Hotel and Lodging Association, hundreds of other trade groups. They got over 200,000 comments on this proposed rule. Unfortunately, 120,000 of them for union advocates that think the rule is great and that everybody should earn overtime, and about 80,000 from business. But there was a lot of logic and research in the business submissions. A submission that we made has gotten some attention, and that is that there should be 4 trigger wages. 1 for retail and service businesses, 1 for agriculture and food processing businesses, 1 for high-tech and financial services, and 1 for other white-collar desk-based businesses that aren't high-tech, medical, or finance. It's not fair to lump us in with Google. I can't tell you if we're going to get that or not. It is likely, because of the volume of comments, that we won't hear anything until February or March of next year, and the change would be effective late next year. Now, for those of you who have salaried people, you can keep them on salary right now. Watch your update. We probably will get 3 to 6 months notice if this rule changes, so that you have to move people who don't make that much money, and many of our managers, maybe most of them don't, back to hourly, but then you'll have to track overtime.
So then right now you're saying that it's my understanding this is going to take place by the 1st of the year.
Not moving that fast.
So it's not moving that fast.
No.
Okay, I'm not continuing what 50 pages of budget, so.
Joe, I don't see any chance that it's going to happen that quickly. They haven't even released a proposed draft revision.
Okay, well, that's good to know.
Now, I am concerned that the next run at this may substitute, may have to do with what they call the duties clause, and may say they have to, a exempt manager has to spend some percentage of his time doing managerial work as opposed to operating work.
That's part of it now, though.
Well,
part of this, part of it, you have to be able to hire and fire.
That's correct, but it doesn't say 60 or 70% of your time has to be on managerial work, and I'm worried that may come. Because your front desk manager checks in guests.
Yeah, but he'd meet that rule, no problem.
I have some members where they may not. Yeah, all right. Any other questions on overtime? Does anyone have the feeling our government is piling on? With the Affordable Care Act and all of that?
Say, Dan, could I mention one thing? Everyone really needs to watch their county too, because counties, sometimes there's suggestions made by the state, and counties take those as law sometimes, and they change their rules, which comes down on us. Our county, for instance, was changing their planning and zoning laws, and just a couple of bizarre changes in this thing were decks alongside campers. Somebody sets a little platform alongside a camper to set a picnic table on, or table or chairs. Couldn't be over 64 square feet. I don't have one that small in my resort. I don't have one that small. That's just one. Another one was that they were going to try to impose on us was every campground it was mandatory to have a storm shelter. And I pushed back on that one, and I said, don't make it mandatory. If you make it mandatory, there will never be another new campground ever built in
Osceola County,
because most campgrounds start with 20 sites someplace, and then they grow. They get something paid for, and then they grow. Now, we put one in, a storm shelter, but we did, and I wanted to do it voluntary. Now, for me, it's something that, it's a selling point for my campground. But if you make it mandatory, you're gonna ruin commerce in Minnesota. So, watching our counties is something that we all have to do.
I agree, we get those calls. Minnesota operates under something called the Dillon Rule, where cities and counties only have the authority expressly granted to them by the state or the federal government. They have some planning and zoning capability. They don't have like HR capability. I don't know that they have the authority to make Stearns County resorts and campgrounds put their phone numbers on their boats, but that, we'll see. It's easy enough, it's probably not worth suing them over. But I agree with Al, counties are fairly aggressive. We will be dealing with a proposal by the Minnesota Department of Labor in the next legislative session to authorize counties to enforce the state building code on all lodging properties in the state. Will pose that, and it's also stupid. It comes from a collapse at Thumper Pond last April in Otter Tail County where the roof over a water park collapsed. Only collapse we're aware of in the history of the resort industry that we know of, at least the modern resort industry. And it's overkill. That kind of plays into Al's point that we gotta watch our counties. They are a source of increasingly excess regulation. When I visited at Maryland's resort yesterday, hearing Mille Lacs County has adopted the state building code, and it's much more challenging to build in Mille Lacs County than in neighboring Kennebec or Crow Wing counties because they haven't adopted the state structure code. And it adds cost and hassle. All right. Auto registration information. I think that police chiefs and county sheriffs must have all gone to a workshop someplace that said a great source of information about criminal activity is the registration at lodging properties, hotels, resorts, and campgrounds, because they are required by law to capture the name, address, contact information, and license rate number of all their guests. Both registered guests and guests to the property, if you have campgrounds and you allow visitors. And they have to allow you, Mr. Law Enforcement, to, and I've heard various comments about this, allow you access to it, make you copies of it, send it to you every day. None of that is true. There is a provision in the state lodging statute that says when you offer accommodations to the public for a fee, you have to maintain a registration log or register, I think it calls it. And you have to record the make, model, license number, and state of license of vehicles. And law enforcement may examine those records upon request. It is increasingly happening. How many of you record vehicle information as part of registration? Nobody. All right. So far, nobody has gotten a ticket for it or been arrested for it. We have had one in Jackson County in southwestern Minnesota, and one in St. Louis County. Sheriffs get unhappy enough to write letters to lodging properties saying, repeating what the law is, and saying that the law makes it a misdemeanor not to comply. You'll have to be your own decision maker as to whether you want to keep it. Those of you with computerized property management systems, relatively few of them have a place for it. Here at Rutgers, you may have noticed that when you checked in, they asked you for that information and they had to write it free form. They didn't even have boxes for it. Most of the branded hotel companies, the Holiday Inns and Budget Hosts and Americans, have added it to their property management systems. If you get a call from a sheriff, it'll mainly be sheriffs, it could be a city police officer. My advice is to ask for forgiveness rather than permission. But you may, if your local sheriff wants to make an issue of it, you'll probably have to keep that information going forward. Questions about that? Now, the toughest one is guests in campgrounds where people come driving up to meet or to visit with people who are staying in your campground. In many cases, we don't know they're there, we don't keep their information. Some sheriffs have interpreted visitors as being covered by the lodging statute. That's a really gray area. Read the statute. It's in the Hospitality Legal Guide. The whole entire statute's in the back of the guide. But so far, we haven't had anybody get a ticket for it. We've had more and more calls about it this year. And more is still 4 or 6 maybe. But the 2 letters from sheriffs have caused some upset. I am concerned about it. Yes?
Where do, we have one meal a week that's open to the public, so guests that come in to eat that meal and watch our show, do they fall under that?
Probably not, because you're not furnishing lodging.
I see, okay.
It
But we're
is-
not to guests of guests either.
And that's why I think it's a gray area.
Yeah,
I think we
okay,
may win
okay.
that one. The people to whom we're renting lodging or a camping facility do fall under the registration
Sure.
requirement.
The hard part is when you have a golf group of 16 guys, and they're
Yeah.
staying in, you may have two units, or 1 unit for our case.
And one registered,
And,
yeah.
well, and even if you have all their names, one guy come and register and everybody else just goes to the cabin,
Yeah.
and,
Okay.
it's almost impossible to get all that information, and, we do try, to get a little bit of information, but it's so inconsistent that it's not worth saying that I do.
Yeah, and it's stressful for your front desk.
Yeah, line of people and,
Yeah.
Dan, this might be a stupid question, but what is the purpose of that? I register all the names and their kids and even ages.
Short answer is, I don't think it has a purpose in the modern world, but when it was written, it was looking for stolen vehicles and kidnapped spouses or children, and trying to track them to a vehicle. I think it's obsolete, it's been in the law since the 1930s, but there are some sheriffs who have enforcement authority and could issue a misdemeanor citation. The penalty for misdemeanor is up to 90 days in jail or $1,000 fine or both. No judge in their right mind will do that, but it would add stress to your lives. And one of my goals is to reduce stress for our members, not increase it. And the one down in Jackson County was a different one than that, and very interesting. They were looking for motor homes that had been purchased in Montana where they hadn't paid the sales tax. And so they wanted license numbers, and they got some. The campground involved was cooperative. They had some of that information and were able to collect sales tax on illegally registered motorhomes. The one in St. Louis County was regarding kidnapping. We want to help, but we may not have that information. And but technically, if you rent accommodations, you're supposed to collect that information. All right, on a much